Welcome to the Finance Garage podcast, your go-to podcast for navigating the world of finance. I'm Jonathan, your financial guide, bringing the latest market trends, investment strategies, and financial news that matters to you. And by the way, I'm also going to share my other passion, which is cars.
At the SWU Group, we help everyday families achieve financial success. Our integrated services include financial planning, accounting, credit advisory, and estate planning. We're here to guide and support you every step of the way, from custom investment strategies to maximizing tax efficiency. We ensure your financial goals are met with peace of mind. Visit simonwu.com.au for more information.
Hey everyone, and welcome back to another episode of the Finance Garage. As always, Jonathan Wu here, Senior Financial Advisor and Principal at the SWU Group. Now this month, we have our first lawyer on the show, Mr. Chris Kintis, who is a Principal at Cornwalls here in Sydney. And Chris is a dispute resolution specialist. Now, Chris has worked for a number of high-profile clients, and if you're looking for his background, you can look him furthermore by going on the socials, of course. But Chris is very, very experienced in dealing with disputes in relation to mainly businesses. Okay? And so from a consumer-facing perspective, as an SME-facing perspective, why I asked him to come on the show is to discuss issues that people face when they are being chased for money or for seizure of assets or other contractual issues that always have deadlines, especially when they relate to courts. And so in this episode, we cover four main things, including the issues around statutory demands and why you shouldn't ignore them. Dealing with personal guarantees, because this seems to be an easy way out for many people to get a transaction moving along and why they are dangerous. We then talk about contracts that create litigation, because people talk about or they have misleading or very vague dispute resolution clauses, and that can cause a lot of issues. And finally, we talk about insolvency as a issue for many, many people, because in Australia, one of the things that I do raise with Chris is that as opposed to the United States, when you go bankrupt in Australia or face an insolvency situation, there is a stigma related to it. And it unfortunately takes away the opportunity in many cases for people to restart. Whereas the Chapter 11 provisions that we see in the US that also relate to personal insolvency and bankruptcy encourages people to be more entrepreneurial, and the system allows them to not be tarnished in terms of their reputation on a longer term basis. And so because, unfortunately, we live in Australia, that stigma, unfortunately, does follow you around and can cause you to have very much long-term issues. So I hope everyone enjoys this episode. As always, please refer to the disclaimer at the end of the episode. And as always, if you have any feedback or any other topics that you may be interested in, please hit me up on the socials. And with that, hope you enjoy today's episode. So, hey, Chris, welcome to the Finance Garage podcast.
Fantastic. Thank you for having me, Jonathan. I'm really excited.
So, obviously, you're the first lawyer on my podcast. There's a specific reason for that. I and Simon advise a lot of small and medium enterprises. And when we talk about things like tax and we talk about things like superannuation, structure is always the most important thing, right? Because there are upfront costs in setting up anything in the world, but if you set it up right, you avoid a whole lot of issues down the track. For us, as advisors and accountants, we're trying to avoid the ATO, right?
Yes.
We're trying to avoid people coming in and liquidating you, or asset protection and things like that. Now, you're very experienced in this area from the legal fraternity side. Sort of first broad macro question to you, right? In the decades that you've practiced, especially in regards to your area of expertise, have you seen litigation rates go up, go down, or has it been just a different context?
I think that litigation rates have been fairly steady from my perspective. But litigation is becoming, or has become, more complicated, more document driven, and because of that, much more expensive. So many years ago, if you look at the way files were prepared, and this is a sort of a good illustration of files, and you would have manila folders, almost half folders with a ribbon around them, and that was the file. Today we've gone to electronic files, so you don't really see the difference from a physical perspective, but most litigation in the Supreme Court, District Court, even a local court, comprises many hundreds, if not thousands, if not tens of thousands of documents, which creates complexity and also creates cost. So, for businesses, being mindful of managing litigation risks involves ideally avoiding a situation where you find yourself having to deal with a scenario where you are required to spend a lot of money defending or prosecuting your position.
If we sort of take that narrative further, and let's look at if your client's on the back foot, they're subject to a potential litigation. A lot of people have this natural tendency, like we see it in our practice, where clients will receive demand letters from ATO and then they just don't do anything. They put their head in the sand and they'll bury themselves, right? And go, oh, it will go away. It's not that big of a deal. ATO can't really be after me, right? So, this whole concept of, legal landmines, especially when people come up with statutory demands, right? There are days in which you have to respond. Why do you think that there are some smart business owners that are truly good entrepreneurs that end up losing perfectly defendable cases? Is that really around just putting their head in the sand, or other things?
I think it's other things. I think that if you put your head in the sand, you are more likely than not to end up having to deal with a court case. But why do people lose court cases? Court cases comprise a lot of moving parts, and everything has to go right. A judge has to accept your version of the facts. A judge has to accept your witnesses as you present them. A judge has to accept the law as you interpret it and you present it to the judge. A judge has to accept the way you review and analyse a commercial agreement that's subject to dispute and agree with your analysis. And if that all doesn't line up, then there is a chance that you will lose the case. And that's why cases are lost, because it's about a judge accepting the law, the facts, and the legal issues as you present them, in circumstances where the judge will scrutinise those matters, obviously, and in circumstances where you have an opponent on the other side saying that things are other than the way you are presenting them. So, the head in the sand scenario is not uncommon. But for most businesses, for all businesses, early intervention and being proactive in obtaining legal advice as soon as there appears to be a risk of a claim or a dispute is the best way to try and shut down or resolve that dispute or prevent escalation.
To a court case.
To a court case,
Yeah.
yes.
Yeah. I mean, what type of broad letters should you not be ignoring?
Absolutely. Broadly, any letter of service.
Okay.
A letter that might be a letter of demand. Now, a letter of demand and ignoring it is not necessarily going to result in an immediate court case, but it's the first step. If you receive a letter of demand, you need to act on it quickly. Get some legal advice on it quickly. Present your version of what has happened. It may stop the dispute escalating. It may slow down the dispute escalating whilst the other side thinks about its position. But if you do nothing in response to a letter of demand, it is likely that the party issuing the letter of demand will think, hey, they're not responding because what we're saying is right, and they're not really going to defend this, and it will encourage the other side to commence proceedings to recover what it says it is owed. The second type of letter that you need to be mindful of are letters serving proceedings. For example, statements of claim. There are strict time limits around statements of claim, being 28 days from date of service to file a defence. If you don't file a defence, then the party serving that statement of claim on you is entitled to obtain a judgment without going through a full or formal court process. And once it has that judgment, it can wind up or liquidate a company or attempt to commence bankruptcy proceedings against an individual. Another letter to be mindful of is a letter serving a creditor's statutory demand for payment under the Corporations Act. This is a demand made on a company to pay a debt. A company receiving that demand only has 21 days to pay the amount claimed or make a court application to set aside the demand. And if it does neither, then the party that has issued that demand is entitled to apply to a court to liquidate the company, which is obviously very drastic and has serious consequences for the directors of that company.
Do you think, as a practitioner, say if I try to draw parallels to what we do, if a client hasn't filed a tax return for 10 years and then they're seeking advice because the ATO is now literally at the door, they're doing all sorts of stuff to basically get to the point of even garnishee notices, and they say, oh, sorry, I sort of forgot about this for 10 years, we would generally just turn the client away, right? You as a practitioner, if you come across, and I'm sure you have come across people that are on the receiving end of letters of demand and whatnot, have stuck their head in the ground, how do you approach it practically? Do you kind of go like, mate, you screwed up, like there's no way of coming back from this?
I think in some cases, the position is that it is very hard to come back from where somebody finds themselves after a long period of inactivity. But even in circumstances where it looks fatal, my approach always is to try and find a solution. My practice is about troubleshooting disputes.
Yep.
Some of those disputes end up in court, but what I try to do is troubleshoot a dispute. And an example of a matter not so long ago that I was involved in is where somebody had ignored the ATO for a long time, ignored a director's penalty notice that had been issued. He was a subject of court proceedings as a result of his failure to pay attention to the DPN. And Jonathan, as you know, it was head in the sand stuff, as you mentioned. When he was referred to me, he had a very short period of time to file a defence to the ATO proceedings. Otherwise, he would have potentially had a judgment against him, which would have entitled the ATO to commence bankruptcy proceedings. We spent time trying to understand his circumstances, and by doing that, we were able to identify a defence that we could bring. But based on that particular circumstances, we were able to prepare a defence in response to the ATO proceedings and ultimately get to a commercial outcome. So although it didn't look great when we were first instructed by this person, our thinking and our mindset is, how can we mitigate, minimise or prevent any further damage, and try to work out what the solutions may be in order to do that.
Even though we're already so far
Even though we're
down.
far down track. And sometimes, rarely have I seen something that's absolutely hopeless.
Okay. All right. That's hopeful. There is hope. Okay.
There is always hope. Even in a winding up context, even a liquidation context, difficult, but you can stop a liquidation by providing an alternate form of restructuring, for example. So, it's pretty much very far down the track where a company might be the subject of a winding up application in order to be liquidated. But even at that late stage, there are steps that can be taken. They are difficult steps, they're costly steps, so you don't want to be there. But there are circumstances where, even though it may seem hopeless, there are some prospects for inappropriate circumstances, inappropriate matters.
Fair enough. Now, another sort of topic that comes up where our clients get asked to basically, let's call expedite a business transaction. And on the surface, it sounds like an easy way out. It makes things quick and easy, and it stops the other side from delaying a transaction of any sort. This issue around personal guarantees, not too dissimilar to even, I remember when I first applied for my first home loan. And I was like short a little bit of capital, and I was like on the borderline of the LVRs. I refused to pay LMI because it's obviously very costly. And the bank said, here's the way to solve the problem. Get your dad, Simon, sign a personal guarantee, right? Then you get your loan. How easy is that, right? Everything is solved by finding a guarantor, right? Nothing is too hard if you find a guarantor. And I've been taught by, many people in the legal fraternity, anyone on this planet asks you to sign a personal guarantee, just never, ever do it, right? Because we've seen it to our clients that, they blow themselves up and then look for us, because there's a lot of directors we've seen sign guarantees without understanding how their business structure is, properly, set up. And so this issue about personal guarantees at a macro level, what's your viewpoint as a practitioner?
I think people need to be very cautious. I think directors sometimes underestimate what they're exposed to. I think directors, in a lot of instances, find themselves in a situation where the guarantee is there. It's part of a credit process and a credit application process, and they just sign in the same way as they sign that credit application without thinking about the consequences. And the consequences can be serious and can be dire. If a company defaults on its obligations, it'll be 100% certain that the person who's provided credit will be pursuing the guarantors personally for any monies lent to the company that they're guaranteeing. So I think that before somebody signs a personal guarantee, well, ideally, it's better you don't.
Yeah.
But practically, it may be unavoidable to sign a personal guarantee if you're running a business, depending on your suppliers. Now, you want to deal with suppliers who may not be requesting personal guarantees, but if you have no choice, be mindful about how much you're guaranteeing. Impose limits. Do not go beyond credit amounts that you are comfortable with. Do not just make orders without considering the overall level of indebtedness. Do not blindly accept the credit thinking that you're going to be paying over time, so it's okay. More often than not, it is okay. But if it goes wrong, and this is I come to each scenario or each transaction that I'm asked to look at from a disputes perspective is what happens if it goes wrong. And so if you've signed a open-ended guarantee without any limits on there, and before you know it, there's several $100,000, and for some reason your business is in trouble and it cannot pay, then you'll be pursued. And if you have assets, anybody who's issued that credit will be trying to have recourse to those assets in recovering its funds.
So that's something I didn't know. I automatically, by default, thought if you sign a personal guarantee, that's just like the laid out misere, of you can go after everything. So you can actually prescribe limits to that personal guarantee. It's not all and sunder.
No, it doesn't have to be.
Okay.
Some guarantees are drafted in a way that are open-ended, but I think that if you want to be sensible and cautious, you would attempt to try and limit the guarantee, or alternatively, make sure you're very disciplined if you can't. And practically, look, it is difficult sometimes for a smaller business to be negotiating with a larger supplier around its terms because they have terms with so many people that they'd rather not. So the flip side is, or the alternative is, be very focused around credit limits that are to apply and adhere to those credit limits and make sure that you are communicating to the supplier that this is the limit and you're only going to be requesting credit up to that limit and don't go beyond that.
Because if I recall practically, right, as a small business owner, myself, the last personal guarantee I made was around the 2 printers that we lease.
Yep.
Again, it's trivial in the scheme of things, right? What is the magnitude of damage that could happen, right? These 2 things go up in a fire, I steal them and run away with 2 printers, right?
Yes. Look, it can be trivial, but be mindful of this. What is the lease payout amount on those printers?
Correct. So what's the terminal value of the lease payout? Correct.
And if it's a 5-year lease, you'll find that it's a pretty reasonable amount for most people.
Yeah, correct.
Yet most people, and most business owners see that as a trivial personal guarantee, perhaps without really contemplating what a worst case scenario may look like. I think the main thing is have awareness. Understand what you're signing, understand what you're guaranteeing, and be confident that you can discharge your primary liability. And if you have concerns, then you need to revisit the terms of the finance that you're going to be provided to mitigate against any potential personal exposure in the future.
So you think would that be the single biggest mistake directors make, is just blindly, without negotiating any form of limits or parameters, and just
I think a lot of the time people are signing because they believe that they have no choice but to sign without really understanding what they're signing. And it's what you spoke about, the speed of doing deals, right? And getting things done. And I get that from a practical perspective. But a few moments of understanding and consideration, and it may mean you need to change suppliers. But you need to, I think, give yourself some time to give consideration to what is the right risk for your business in terms of the contract you're entering into, which is effectively what a guarantee is.
Let me raise this as a sort of a side question to these personal guarantees. Let's use my case of those 2 printers that I lease, right? I think I pay $500 a month for the 2. The lease plan, I think, is 3 years. And, they can chase me for that terminal amount for the lease value, right? If I stop paying or something happens to me. Plus interest and whatever, stuff that you lag on top of it. These sort of scenarios bring up that practical question. Let's say I actually did default. Let's say the value of those, $500 a month for 3 years is, let's call that 20 grand, including costs, right? Is there practical consideration on behalf of, let's say, the printer company that goes, I know the guy owes 20 grand. Let's say I defaulted on day 1, so the terminal value is 20 grand. Like, this is going to cost me more than 20 grand to litigate. Screw it, right? Is that a practical consideration? Because I've seen business owners think that way. I'll sign these personal guarantees. Here's a terminal value of a piece of debt or the credit I'm acquiring. And then, got to be too small for them to litigate.
Yeah. Look, I think that is not an unreasonable consideration, but it depends on who you are. So let me give you an example, because I think this illustrates things well. Many years ago, and funnily enough, it had to do with a very large commercial copier.
Okay.
And the lease payout amount was several $100,000.
Okay.
This person was involved in a family law dispute that had a cascading effect where his company ended up going into liquidation. It could not meet the payments under the lease agreement that had been entered into, and he was exposed to a very significant claim as under a personal guarantee that he signed. Now, he didn't have much, and despite lawyers being involved and pursuing a large sum, we did a very good deal for that person, because in this particular case we were able to say, hey, there's no point in you going after this person. Now, sometimes that works, sometimes it doesn't. So from my perspective and my experience, even though it's a small amount, it depends on who it is who's making the decision. Sometimes, even though it's a small amount, a lender or a financier is happy to go ahead and pursue the $20,000. So you can't assume that you'll necessarily be able to walk away if you don't pay because the amount is a small amount.
And do you think that that's also can be attributed to the fact that even though it on the surface looks like a trivial amount, if I don't pursue it, my name would also, get into the market going, I'll never pursue you for debts.
I think that's right.
Yeah.
I think it's part of it.
That's part of it, yeah.
And the reality is that it is absolutely uncommercial to sue for $20,000. You are significantly out of pocket.
Yep.
Because there are caps on the legal fees that you can recover, even if you win the case. So it really makes no sense to sue for $20,000, especially if there's going to be some sort of defence. But a lot of the time, claims for $20,000 are made because there is an expectation that the person who's being sued is unlikely to defend the matter, and so there'll be an easy judgment. So if you think it's going to be an easy judgment without a defence, then that's why somebody would sue for $20,000.
Still go for it, yeah.
Right? Because they can get what is known as default judgment, which is a judgment because a defence hasn't been filed, rather than a judgment because a judge has heard both sides and then comes up with a decision.
Yep.
So a financier can obtain a judgment within a month if somebody doesn't respond.
Now, that's an interesting point as well, because if you obtain a default judgment because the opposing side did not place up a defence or filed nothing in response to your demand, is there a level of weakness attributable to that default judgment? Because the defending side could come back and say, raise all sorts of excuses like, I was never served properly, I didn't know this was going on, I was busy with other stuff. Because both sides weren't heard, is there a risk of default on default judgments?
Absolutely. Absolutely. There is a weakness in a default judgment. And that's because if a judgment is obtained by default, it is open to the person against whom that judgment's been obtained to apply to a court to have it set aside. And you can have it set aside if you can show that you weren't served with the statement of claim and that you have a defence to the case. And if you can establish those two matters, it is likely, it's not always guaranteed, it is likely that a court will set aside a judgment and give you time to file a defence. Courts generally don't like to make decisions or enter judgments in the absence of a party. The principle is that everybody should have their day in court and should be given a fair go to defend their position. So there is that vulnerability in default judgments, and that's why it's, service and ensuring proper service and ensuring proper evidence of service is maintained is very important for anybody who is instructing a lawyer to commence proceedings.
Okay. So while the default judgment looks like you've got your slam dunk, the takeaway is be aware people can have them set aside.
Yes.
Yep. Because of the basic nature that our legal system is adversarial and people should have their ability to defend themselves.
Correct.
And have you personally been able, in your experience, or one of your colleagues in your team been able to turn over a default judgment? Have you seen it happen?
And we have, and we have had a case very recently where a significant amount of money was involved, and where there were issues about the proper service of the claim. And in this particular case, there were a number of personal reasons that impacted our client, and significant personal reasons, and those reasons were sufficient for the court to appreciate that there was a good reason for a defence not having been filed. And secondly, we were able to demonstrate that there was a defence to the claim. And it's very important to be able to show that although there's a reason for you not filing a defence, you also have a defence.
Okay. So it's not a mutually exclusive concept of you can't have one without the other. Both of them needs to be equally valid.
There are two issues that a court will look at. Why a defence wasn't filed and is there a reasonable defence on the merits? And the court, you don't have to prove all your case when you're applying to set aside a default judgment, but a court will reasonably want to be satisfied that the defence you're putting forward is a reasonable defence. If you can't show that, then there's a chance that even though you might have a good reason for not filing a defence, if you can't show a defence, a court may say, look, there's no point in allowing this matter to continue because there is no real defence on the merits.
Ready to take the first step in investing, or just looking to continue growing your wealth without being inundated with financial information? With SWU Online Invest, we offer a range of expertly managed portfolios designed to match your investment needs. Whether you're a seasoned investor or just getting started, know that we will work tirelessly to ensure your investments are strategically positioned to maximize your goals. Visit swonlineinvest.com.au today.
Let's move on to contracts that create litigation. Okay, so each and every day, small business enterprise operators, like a lot of our clients, sign lots of contracts. Lease contracts with, your Westfields or a shopping centre, contracts with suppliers. And in a lot of contracts, there are clauses that relate to dispute resolution.
Yep.
So your area of expertise. Now, a lot of those can be default or, in the advice world, we have, these concepts called EDRs, right? External dispute resolution programs, so on and so forth. So some people go into these contracts thinking, okay, if you and I, as two parties to a contract, disagree with something, well, we've got dispute resolution clauses built in. So we both know what obligations we have with each other in the event of a dispute. What's your view on that? Because I think that the way that these clauses are crafted has big issues, and or especially with regards to things like penalties, right? How do you deal with that, and what's your sort of broad advice for SMEs?
Well, I think dispute resolution clauses in contracts are a good thing. A properly drafted dispute resolution clause has a number of layers. And with a number of layers, you find that parties generally are not launching straight into a court action, and they're giving themselves some time to try and get to a resolution. And the layers usually look like this. A starting point is a negotiation or discussion between executives or chief executives. The next layer may well be a mediation. Beyond that, there may be alternative processes to formally resolve the dispute, arbitration, expert determination. The starting point in terms of a cascading alternative dispute resolution clause usually looks like this. A meeting between chief executive officers, for example. Secondly, it is more likely than not to contain a mediation clause. Now, for a mediation clause to be valid, it needs to be precise. The parties will mediate as opposed to the parties may mediate. It needs to provide details of who the mediator will be or precise details of how the mediator will be appointed, as opposed to, as I mentioned, the parties will agree to discuss how a mediator might be appointed. You're going to find yourself in difficulty if you are the party that wants this mediation to go ahead. And the importance of a valid mediation clause, for example, is that it prevents a party suing until such time as the mediation process has occurred. And if my client decides that it wants to sue despite a valid mediation clause, the other side is entitled to go to court and halt the proceedings, or even attempt to have the proceedings thrown out if there's a different form of resolution in the contract, for example, arbitration. And I think mediation is an effective way to resolve disputes. The reality is, in most litigation in New South Wales, the majority of commercial disputes in the Supreme Court will end up at a mediation at some point during the currency of the proceeding. So having an opportunity to mediate early, for me, is a very effective tool for a business to try and find a compromise, either irrespective of which side of the argument it's on, to a commercial dispute. Because in reality, if you're in litigation, in 15 or 18 months' time, you'll be mediating again, having spent a lot of money to get there, and perhaps with a lot more clarity around what the case looks like, because there'll be witness statements served and correspondence exchange on various issues, but it's still a mediation that's going to occur, but later, and also involving a fair amount of money.
Just so, because I don't think even I'm too sure of these concepts, is there a difference between arbitration and mediation?
Yes.
What is that?
Yes.
What's the difference?
The difference is that mediation is a process where a facilitator tries to get two parties who are in dispute to come to an agreement. Mediators usually don't provide a view, usually don't make any decisions, don't provide advice. They encourage and facilitate the discussions, leaving it to the parties to reach agreement. Arbitration is a different process. It is a process where an arbitrator has power to hear from the parties, review their evidence, hear their legal arguments, and come up with a decision, and a binding decision. You could probably put it or describe it as a mini court case, because effectively it is a court case being run with witnesses, but it is more likely not to be private as opposed to a public court case. And arbitration is usual in particular industries or where you have international commerce, because you utilise rules, international rules of arbitration, so that no party is being prejudiced really by having to litigate in somebody else's backyard. But arbitration is a binding process, whereas mediation is a process of facilitation, and really the focus and the onus is on the parties to work with the facilitator, being the mediator, to try and get to a resolution. But the mediator cannot impose a decision.
And have you seen cases where they sort of flip between the two, in the sense of two parties have gone down the route to mediation and they end up not being able to achieve much there, then they end up in arbitration, then they're up in a full-blown court case, and then they end up back to mediation, and it just goes round and round circles?
Look, it can. With arbitrations, you can get to a full-blown court case, but really it's limited to some fairly precise areas of appeal out of an arbitral award. But what does happen is that a mediation might fail, the parties engage in an arbitration process, and in the context of the arbitration process, there is a further mediation that occurs. And that's a case that I was involved in a few years ago where that scenario played out. There wasn't a resolution achieved prior to the arbitration, but as the arbitration became bigger and more complex, both sides saw the need to try and revisit settlement. So it went to a mediation whilst the arbitration was on foot.
Staying on contracts, let's deal with the massive landmine issue, oral contracts.
Yep.
So hard to prove. Who said what, when? Are handshake deals ever safe?
I would caution anybody about doing a handshake deal. It is very, very difficult to have any real precision when you shake hands on something. Look, some people may well be trustworthy, and you may deal with somebody who you believe. You may deal with people that you think are honourable people, and you can deal with them with a handshake. Now, they probably are honourable people, but in 2 or 3 or 4 years' time, when an issue arises, and that person's recollection of the conversation is very different to yours, it becomes very, very difficult to work out what the true position is. There is no written document that sets out obligations or rights. And so you are encouraging a situation of uncertainty and potential risk in a court case where a decision as to what this contract looks like really will depend on how people perform in the witness box and whether a judge believes one person's version over the others. It's very unsafe for deals to be done in that way, even though people think it's been done in good faith and with the person who is going to honour that handshake. Their assessment's probably right, but recollections change, and you also lack the degree of precision required in any sensible commercial agreement when you shake hands with somebody.
I mean, even a WhatsApp message is better than a handshake.
I believe so.
And I think that's where a lot of people also we've seen get into problems where they come to us and said, but he agreed to that. I said, how? Well, we agreed as a gentleman. Well, if you're in now dispute resolution, there's nothing really called gentleman about it all, right?
No, that's right, because if somebody's in dispute with you, the chances are that they're not going to agree with what you say was said. They're going to dispute it and they're going to put you to the test. And it becomes complicated and expensive to go through whatever period of time has elapsed since that handshake agreement and try to piece together a case that demonstrates to a court that, hey, this is the agreement we came up with. It's difficult.
The last topic we want to sort of explore is, and this is, we sort of set out this topic as a little bit controversial, but insolvency is a process problem before it is actually a money problem, right? So you run your small business. Insolvency litigation of itself could start months before a business actually goes, oh, I've got no money, right? And there's a lot of procedural missteps because, at the end of the day, as we've discussed in today's episode, law is about procedure. A lot of it is about procedure and a certain order of events. People that operate businesses well know when they possibly will get into trouble, whether they believe it or not. And we talked about the whole put your head in the sand issue earlier, right? Whether or not they accept it, they're in denial. Other than that, people that run a business know intuitively through gut instinct if they're going to be in trouble, right? So before someone like me, being the accountant, says, months later after we do a BAS or whatever and say like, hey mate, I think you're in trouble. What do you think directors should do? Because they well know it live that if they're in trouble, what should they do?
I think that it's important to ensure that, directors fundamentally have an obligation to act in the best interest of the company. And in doing that, I think importantly, they need to be on top of the financial position of the company at all times, because that also informs them as to what steps they might be taking if they consider that at some point in the future, the company may be insolvent, as opposed to a situation where insolvency is sort of thrust upon you by the accountant saying, what's going on here, in circumstances where you have not been keeping an eye on the overall financial position of the company. So I think that's very, very critical. Making sure books and records and financial statements are all up to date. Making sure from a compliance perspective, all those documents are up to date and complete. Because absence of books and records and absence of financials has consequences in the event that the company ultimately were to go into liquidation. And those consequences are consequences for the directors. And the other thing, of course, is ATO compliance. Lodgements up to date and ideally payments up to date. But ensuring that you've got the ATO compliance up to date is important because it also has impact on what a company might do as part of any restructuring process down the track if the accountant says, hey, you need to look at your solvency. But I think those three key things are important. And also in terms of the financial position and overseeing that financial position carefully is the important matter of being mindful of what debts you're continuing to incur.
While insolvent, or when you start feeling
when you start feeling, when you start having some concerns, because then you start straying into that insolvent trading territory. So it's important to be very mindful of the financial position, because that will allow you to make some decisions or get advice around how the company is tracking and what level of debt, if any, you should continue to accrue.
If you're a small business operator and you might be doing this for the first time, from what we can see as accountants, most people don't understand directors' duties. Right. What is the broad risk, in as simple terms as you can put it, about trading insolvent? Because I think a lot of people don't actually understand the consequences of knowing you're insolvent.
Yeah. The broad risk is that if your company goes into liquidation, there is a chance that a liquidator may pursue you as a director personally for those debts that were accrued by the company at the time that the company was insolvent. So that's the risk you run. And the chances are that a liquidator would at least issue a letter of demand setting out the reasons why you're liable, but it is a common claim that will be made in any insolvency, because it is not unusual, as you know, for people to be trying to bail out their company.
Correct.
And they bail out by continuing to trade, and they may bail out by continuing to incur debt.
Yes.
But sometimes they're in too deep and it's a little bit too late. So go back to my first point about ensuring that you really are tracking and are on top of the financial position on a regular basis. In that way, when to get advice or when to stop incurring liability to mitigate against the risk that the company's in liquidation, and then you're a liquidator who is making a claim against you for insolvent trading.
Because I think that I'm keen to get your opinion on this. I was listening, I think in another podcast, or we were talking about bankruptcy laws, or I may have even was reading one of your own articles that you published. In Australia, it seems that bankruptcy is like the end of the road, right? Like you get declared bankrupt 3 years and 1 day, if you're a compliant bankrupt. But in the US, it's seen more as a refresh, right? And it's not taken as, I wouldn't say it's seriously, but the way that it was put to me was that the US system, through their Chapter 11 and things like that, allows and encourages people to make mistakes, and they encourage entrepreneurship. Whereas if you are made bankrupt in Australia through yourself or someone made you bankrupt, like it's almost impossible to get credit in the future, and like it's a massive black mark. Do you share that opinion? And therefore, in a place like Australia, it is so important to not get yourself anywhere near bankruptcy, because the long-term ramifications are just so high compared to someone like the United States.
I think that's right. I agree with that. Unfortunately, for some people, there is no choice. It's either forced bankruptcy or sometimes they make themselves bankrupt. But the practical reality is that it's not the refresh that you describe in the US. There's a stigma attached to it.
That's the best way to put it.
It's always been around. Credit becomes very, very difficult. It's going to be very, very expensive. So restarting after 3 years and 1 day, if you're a compliant bankrupt, is not going to be easy, because the price of money, if you're trying to re-establish yourself, is going to be expensive, and you're going to have difficulties in a number of areas with a credit default that's going to sit around for a number of years post bankruptcy, which is going to hurt some of your efforts in terms of getting finance. So it's an unfortunate reality of our system where that stigma remains, despite the fact that people find themselves in that situation because they have tried to run a business, they have been entrepreneurial, but things sometimes, despite best efforts and despite best attempts, just don't work out. So the US description, or the way you have described the US, is consistent with that breathing space scenario and the reset scenario, which we don't quite have here. May well be something in the future, but there's still a bit of a mindset, I think, that we need to shift around that.
So, today we covered off a range of topics. We could sit here all day to talk about this because there's always a billion ways business owners will get themselves into trouble. And I think the biggest takeaway is business owners are busy working in their business, right? So things that are furthest from their mind is, I signed a lease agreement, a number of years ago, right? They would never sit up at night and go, oh, I remember that dispute resolution clause in that contract with that supplier, that probably might not hold up. And the whole point of this episode is to trigger people, not in a negative way, because it's about just, things that can go wrong, that people can seek advice from people like yourself, is critically important without ending their situation to be in litigation.
That's right, Jonathan. And I think the key is that business owners obviously need to focus and run their businesses, and they can't be afraid of making decisions or afraid of running businesses. But I think it's important to ensure that they are aware of those contracts or those agreements that might, and it's always a small might, become problematic in the future, and get early advice on any significant contracts that they're entering into. Because without that, you really are not giving yourself a fair chance of being aware of what the risks may be and what you do with those risks if they eventuate. So it's important to get early advice, and it's also important to get good and early financial advice, because I say to all of my clients, you need, I won't say you need a good lawyer because I'm their good lawyer, but
of course,
I say to people that I know, it's really important to have a legal advisor that you can trust, and it's really important to have an accounting advisor that you can trust and rely on. And if you have those two people who are working with your business and who will help to alert you to things that you need to be aware of, then it significantly reduces the risk of your business being in conflict or litigation.
Correct. So you can hit Chris up on all the socials. He's very active on LinkedIn. Kintis is spelled Kintis, first name Chris. Lovely to have you on the podcast today. I'm sure we'll have you jump back on in the future, because, to be honest, the material that you gave me and the amount of stuff that you've published over the years, so we could talk forever. But, as we said, today is sort of the starting point where we hope that business owners and clients of ours sort of understand that there are risks. As much and as busy as they are running their business, they need to be aware of these things, because no one wants this to end up becoming a distraction away from people trying to make a living.
That's right.
That's exactly right.
And it doesn't need to be a distraction. It is part of doing business. And in the long term, it minimises the risk of serious distractions and expensive distractions.
Correct. So as always, remember that today's podcast is not legal advice nor personal financial advice, and please seek the advice of your appropriate professional, and please remember to listen to the disclaimer at the end of today's episode. But with that, Chris, thanks very much for your time.
Thank you, Jonathan. It's been great being with you.
This podcast is not financial product advice and is intended to provide information only. It does not take into account the investment objectives, financial situation, or needs of any person. You should assess whether the information is appropriate for you and consider talking to a financial advisor before making any investment decisions. Any investment examples are for illustrative purposes only. The information is taken from sources which are believed to be accurate, but Simon Wu, Jonathan Wu, SWU Financial Planning, and Personal Financial Services Limited accept no liability of any kind to any person who relies on the information contained in the podcast. Unless expressly stated, none of the information should be taken as a recommendation. For more information, please visit www.simonwu.com.au.